Good afternoon, class. For today's lesson, I will be discussing to you the Learn Objective 4.2, the obligation of the debtor and obligor, in which the debtor and obligor is determined into four ways, and these are the obligation to give a specific or determinate thing. Number 2 is obligation to give a generic or indeterminate thing. Number 3 is obligation to do, and lastly is obligation not to do. So the first one that I'm going to discuss to you is the obligation to give a specific or determinate thing. So like for example, a car. You specify all the plate number, the color, and the brand of cars. Like for example, Toyota XXM 456 color red. While in the obligation to give a generic or indeterminate thing is that you just specify the car, not the color, not the brand, and not the plate number. So that is the differentiate between the two. In the obligation to give a specific is that you specify all the plate number of the car, the color, and the brand, while in the generic is just you just pinpoint the car. So let's move forward to the last two obligation, is the obligation to do and not to do. From the definition of obligation from the Article 1156, an obligation is a juridical necessity to give, to do, and not to do. So what is juridical necessity? Juridical necessity means that the court may be asked to order the performance of an obligation if the debtor refuses to perform it. So there are two parties in an obligation. These are the debtor, which is the party who is obliged to perform the obligation, and the creditor is that the party who has the right to demand the performance of the obligation. May I repeat? Debtor is the party who is obliged to perform the obligation, and creditor is that the party who has the right to demand the performance of the obligation. So in the obligation to do and not to do is a personal obligation. So in that case, pwede pa natin siyang hatiin. So si obligation to do, ang tawag dyan ay positive personal obligation. While in the obligation not to do is negative personal obligation.
Duties of debtor or obligor in obligation to give a specific or determinate thing. Number 1, to deliver the thing. Example number 1, kaslalang kung malete, broken family. Idyo contract na pinarmaan da, naka-specific ije nga dapat ni father kat suportara na iti anak na iti 10,000 pesos every month. So dapat 10,000 pesos every month iti itad na haan nga takay kayat na. Number 2, kasalang kumani A, nag-order iti 3-tier cake, chocolate cake kani B. So ni B nga obligor, dapat ti itad nan tumot lang kani A nga in-order na, tay 3-tier nga chocolate cake, han nga yema cake or vanilla cake. Example number 3, kasalang kumani debtor. Ni debtor, imutang iti 10,000 pesos kani creditor. Tapos, tiingbaga ni creditor iti agreement, nga ton agbayad, dua nga buryas tula ta ibayad nan. So, dapat, ni debtor, dapat dua nga buryas tumot iti ibayad na kani creditor. Kasi, inya specific or inya specify na no anati kayat na nga maibayad to kanya na. Number 2, to take care of the thing before delivery or Article 1163. The debtor or obligor must preserve the thing. The obligor has the incidental duty to take care of the thing due with the diligence of good father of a family pending delivery. Diligence of good father of a family. The praise has been equated with ordinary care or that diligence which an average person exercises over his property. Saan ko man example number 2. Dapat, before to i-deliver ni B kun take 3-tier chocolate cake kun ni A, dapat alagaan na, dapat i-preserve na, dapat noon gusto before na nga i-deliver. Dapat kat han nga mabubuot, kasyay dapat kita namot lang diligence of good father of a family no kasanot pinang protekta pinangalaga iti may nga tatang iti may nga pamilya na kasi dapat mat pinangalagam before mo i-deliver kani oblige. Ang command number 3, dapat ni debtor or obligor dapat alagaan na deti dua nga buryas nga ibayan nanto kani creditor or the oblige. Another is standard of care. If the law or the stipulation of the parties provides for another standard of care or slight or extraordinary diligence, said law or stipulation must prevail. No, kasla lang kuma example number 3, ni creditor kung mga agpabayad iti dua nga buryas. No, kuna na iti contract nga dapat no sakbay mo to ibayad ta dua nga buryas, sakbay mo to itad kanyak, alaga ampay lang nga nasaya at dapat pa kanam 3 times a day, padigusam 2 times a day, kasyay dapat mamitlom so katan iti paginuman na. No imbaga na kadyay dapat ni obligor or ni debtor dapat ubraan na digidjay sakbay nanto nga i-deliver ka ni creditor or obligee.
So good day everyone. For today's video, I will be discussing to you the continuation of duties of debtor, obligor in obligation to give a specific determinate thing. So we are now at the number 3, which is to deliver the fruit of the thing. The article 1164. So article 1164, or to deliver the fruit of the thing. So article 1164, the creditor has the right to the fruit of the thing from the time the obligation to deliver it arises. However, he shall acquire no real rights over it until the same has been delivered to him. So according to what I have researched, I have a very good example here. So Juan and Pedro. So Juan sold his horse to Pedro for 15,000. No dates or condition was stipulated to the delivery of the horse. While still in the possession of Juan, the horse gave birth to a colt. So who has the right to the colt? So in a contract of sale, all the fruit shall pertain to the vendee from the day on which the contract was perfected. So that was on article 1534. So Pedro is entitled to the colt. This holds true even if the delivery is subjected to suspensive condition or a suspensive period. If Pedro has paid the purchase price. So, but one has the right to the colt if it was born before the obligation to deliver the horse has arisen, and Pedro has not yet paid the purchase. So that was an article 1164. So according to the article 1164, one has the right to the colt because the colt was born before the obligation to deliver the horse, and also if Pedro has not yet paid the horse or the purchase price. Okay, so let's go back to the article 1164, which is to deliver the fruit of the thing. As mentioned by law, fruits can be referred to a natural, industrial, and civil. So first one here is we have the natural fruit, the spontaneous product of the soil and the young and other product of animals. Example here is the grass. All trees and plants on land produced without intervention of human labor. For example, kumakat di mangga, nagbunga. Tapos, nung nagbunga na, tapos biglang nagtubo. So the DJ, makungkuna nga natural, for example, iti natural fruits nga, nagtubtubulatan without any intervention of human being. Tapos, in second is we have the industrial fruits produced by land of any kind through cultivation or labor. We have example here like sugar cane, vegetables, rice, and all products of land brought about the reason of human labor. So, kasi lang ko rice ko na natatay. Iso nga ada makong ko na nga manalon, tapnon, ada iti nagiji ag-produce iti kanin tayo nga inapoy. Without farmers, awan iti kanen tayo nga bagas or inapoy. Nga awan ti maisaan tayo nga inapoy kasi syempre awan iti farmers. So di makungkuna nga industrial fruits. It needs the help of human being. Tapno non makaproduce iti DJ nga product. So the last one is the civil fruit, derives by virtue of a juridical relation. So what do we mean by juridical relation? Is a legal relationship between person that is governed by a private law, deals with rights and duties of parties. So civil fruit, as on the other hand, are the income or revenues derives from a property itself. So we have here the examples like rent of buildings, price of lease of land and other property, and the amount of perpetual or life annuities or other similar income.
Number 4. To deliver accessions and accessories. Letter A. Accessions. The fruits of a thing or additions to or improvements upon a thing. The principal. Magagamit pa rin ang principal thing whether or not may accessions. It includes everything produced by a thing as well as all incorporated or attached with it, may it be natural or artificial. Accession discreta, right to the fruits. Accession continua includes both accession natural and accession industrial, in which the build landed or sold on the land of the landowner. B. Accessories. Things joined to or included with the principal thing for the later's embellishment, better use, or completion. If wala yung accessory, hindi magagamit yung thing. Includes things that are united or attached as ornaments to the principal thing, the later's use or perfection. Spare tire of a car, television, antennas, cell phones, chargers, movie house, chairs, and many more. Note: bagamat kasama sa paghatid ng tiyak na bagay ang lahat ng mga accessions at accessories nito, maaaring itakda ng mga partido sa kontrata na maaaring hindi kasama sa paghatid ang ilang partikular na accession o accessories. May kalayaan ang magkabilang panig na itakda ang mga ganitong bagay. Number 5. To pay damages of fraud, negligence, delay, or contraventions of the terms of the obligation, Article 1170. Nagsasaad na ang mga magkasala ng pandaraya, pagkantala o kapabayaan sa pagganap ng kanilang mga obligasyon o ang mga taong sa anumang paraan ay lumabag sa tenor ng kanilang mga obligasyon ay maaaring managot para sa mga pinsala. Ang mga nagkasala ng paglabag sa kontrata ay hindi maaaring makulong dahil ito ay kasong sibil at hindi krimen. Gayunpaman, maaari silang managot para sa mga pinsala.
Duties of debtor or obligor in obligation to give a general or indeterminate thing. Number 1, to deliver the thing. Ni A kan ni B kumanda kontrata da. Example, ni A is una obligee, ni B kat obligor. The agreement da ni A, ipaalaga na kan ni B jay daga. Di dagahan na imbaga no, sumakin bagi, no adaba mula na ijay or adabalay na. So, DJ service, no braan ni obligor, iso DJ i-deliver na or iso DJ duty na kani obligee. Number 2, to bear the expenses of having someone else comply with the obligation or Article 1165. The agreement the A kan ni B nga i-take care na DJ daga. Tapos ni B nga obligor nangala iti sa bali nga tao nga mangalaga DJ daga. So isu ni C. No ni C, ada masapon na ko mga fertilizer, no naman di masapon na ka DJ daga, haan nga ni A no ko nga obligee, iti pangalaan na kada pagdawatan na di iti masapon na, ni no ko obligoran, ni let ni B no kwan. Iso dapat ti makaangmog ka di itay, iso na makin obligasyon ka di iti masapon ni C, nga inayaban na nga, mga laga ka DJ, daga, nga kontrata da, kani A. Number 3, to pay damages if guilty of fraud, negligence, delay, or contravention of the terms of the obligation or Article 1170. No kasalang ko man ni A kan ni B daw kontrata da nga alagaan ni B DJ daga. Tapos insalda na gayam nga hangaan mo ni A nga oblige. DJ no kwa insal no naamuan ni A ko mga oblige. Digite kasang ko dito per di DJ daga or DJ dite kwarta nga naglakwan na dapat ito na or bayadan na dapat kan ni A nga makin bagi talaga DJ daga iso na pay dapat ti makin obligasyon nga mangsango di kiti consequences na no in case makulong kasi di pinagswitik na ni fraud DJ.
Of debtor or obligor in obligation to do. Number 1, to do the obligation. We must possess our obligation in taking action or deliver the right to a person. Number 2, to bear the expenses of having someone else comply with the obligation, Article 1167, Part 1. The obligation in holding expenses to a person and comply good situations. Number 3, to undo what has been poorly done. Article 1167, Part 2. The debtor, hindi niya nagawa ang kanyang obligasyon.
So hello guys, for today's discussion, I will just continue what is discussed in the duties of debtor obligor in obligation to do. So we are now at number 4. To bear the expenses of having someone else undo what has been poorly done. On Article 1167 Part 2. So it says here, it is stated here, if a person obliged to do something fails to do it, the same shall be executed as his cause. This same rule shall be observed if he does it on contravention of the tenor of the obligation. Furthermore, it may be decreed that was what has been poorly done. Kapag ang tao ay obligado na gumawa ng isang bagay ngunit hindi niya ito nagawa, ito ay maipapataw sa kanya. Itong panununtunan na ito ay dapat obserbahan kapag ito ay ginagawa niya na kontra sa tenor ng obligasyon. Ito ay masasaad na kung ano ang napabayaang gawin ay hindi na dapat gawin. Some research, Article 1167 refers to an obligation to do, to perform an act or render a service. It is contemplated 3 situations, whereas the debtor fails to perform an obligation to do, or perform obligation to do but contrary to the term therefore, and the perform of obligation to do but in a poorly manner. If the debtor fails to comply with his obligation to do, the creditor has the right to have the obligation performed by himself or by another unless personal consideration are involved. At the debtor expenses and to the recovered damage, in case the obligation is done in contravention of the term of the same or poorly done, the court may order upon complaints that it be undone if it is still possible to undo what was done. If the debtor fails to perform the obligation to do, note that the creditor could ask someone else or a third person to perform the obligation to do at the expenses of the debtor. So, number 5. To pay damage if guilty of fraud, negligence, delay, or contravention of the term of the obligation at Article 1170. So, according to the research, those who in and perform of their obligation are guilty of fraud, negligence, or delay, those who in any manners contravene the tenor thereof are liable for damage. Ang mga nagsasagawa ng kanilang obligasyon na may kasalanan na fraud, negligence o delay o balam at sa mga nagsasagawa ng kanilang obligasyon na hindi ayon sa napagkasunduan ay may mananagot na mga danyos. It is stated there in the module that fraud, a false representation of matter of fact, whether by word or by conduct or by false or misleading allegation, or by concealment of what should have been disclosed, that deceived and intended to deceive another so that the individual will act upon to her or his legal injury. Another one is negligence, conduct that falls below the standard of behavior established by law for the protection of others against unreasonable risk of harm. A person has acted negligently if he or she has departed from the conduct expected of reasonable prudent person acting under similar circumstances.
Before I explain that case, let me explain first what is forbidden. Forbidden means not allowed, banned, prohibited, and etc. Something that is not allowed. So number one, it say not to do what has been forbidden. For me, means that not doing the things that is not allowed to do. Like for example, the sign, no smoking in this area. When you smoke there, you will be accused by people who can see you doing it, or they call up police just to ask you to stop doing it. So it means that you must not to do that are prohibited. And next, number two, to undo what has been done that is forbidden. Just like what I said in the statement number one, when you smoke in a wrong place, you cannot undo it because you've done it, unless you use the time machine to undo it. But for me, you must be aware in your surrounding and look for sign whether it is forbidden or not.
To bear the expenses of having some else undo what has been done that is forbidden. Art 1168. I can see any citation or other mention of the source of the quotation which might help to clarify its interpretation. I have done a few quick internet searches and it's apparently from Article 1168, but I couldn't work out what that was a section of nor to which country it applies. From a grammatical interpretation alone, obligation to undo what has been done that is forbidden means a duty or legal requirement to correct, put right, or reverse the effects of undo what you did was to have been done that you should not have done as it was forbidden. If, for example, you have built a garage, help of which is on your neighbor's property, you have an obligation to undo what has been done, or perhaps you could buy that piece of property. To pay damage if guilty of fraud, negligence, delay, or contravention of the terms of the obligations. Art 1170. Article 1170 of the Civil Code states that those guilty of fraud, delay, or negligence in the performance of their obligation, or those who in any way contravene the tenor of their obligations can be held liable for damages. Those guilty of fraud, negligence, or delay in the performance of their obligation, and those who in any manner contravene the tenor thereof are liable for damages.